A month after I sentenced him, I received a letter from the man he had pointed a gun at. One sentence in it said he came every Tuesday, Judge, and he pushed the lunch carts without talking unless somebody spoke to him first. I read that sentence twice. Then I set the letter down and sat with it for a while. I want to tell you how we got there. When that letter reached me, the case was already over in the formal sense. The order had been entered. The deadlines had run. The room where I had spoken the sentence had gone back to its usual rhythm. But some cases do not end when the clerk stamps the paper. Some cases keep working on you after the people have gone home. This was one of them. The first thing I had seen was not a face, it was a file. The file was thick for a misdemeanor case. Dispatch log, body camera footage, a use of force report, a second report correcting the first one, a complaint from Internal Affairs. A statement from a 74-year-old man named Elijah Reed, written in large, careful print because his right hand shook when he was upset. I read every page, then I read them again. I want you to subscribe before I keep going, not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. What was before me on paper was plain enough. On Friday, November 17, 2023, at 6:42 p.m., outside the Family Dollar at 570 Broad Street in Providence, Officer Daniel Mercer responded to a call about a suspicious male lingering near parked cars. The man was Elijah Reed. He had just left the pharmacy with a paper bag, a receipt folded in his coat pocket, and a cane in his right hand. Within seconds of getting out of the cruiser, Mercer drew his gun. The first report said Mr. Reed had reached suddenly into his waistband and advanced. The body camera said otherwise. It showed an elderly man trying to understand, shouted commands while traffic passed behind him. It showed his left hand rising slowly. It showed the cane. It showed fear. It did not show a threat. By the time I reached page 7 of that file, I knew the officer had not merely overreacted. He had written the moment afterward as if the camera had not existed. Daniel Mercer came into my courtroom 3 months later wearing a navy suit that was a little too tight across the shoulders. He was 38 years old. He had cut his hair short enough that his ears looked larger than they probably were, and he carried his own binder under his arm instead of letting his lawyer carry it. Before he sat down, he glanced once toward the gallery, saw Mr. Reed's cane resting against the bench, and moved his chair back a few inches so the cane would not get knocked to the floor when people stood. It was small. I noticed it. I did not mistake that small act for innocence. I am careful about that. A person can be thoughtful in 1 second and cruel in another. Court teaches you that quickly. But I have also learned not to throw away what I can see just because it complicates what I already think I know. Daniel Mercer did not walk in with the hard face some officers bring when they believe the room owes them deference. He looked tired. More than that, he looked ashamed of being seen there. Elijah Reed came in behind his daughter Loretta, moving slowly but not weakly. There is a difference. He wore a brown overcoat buttoned all the way up, even though the courthouse was warm, and he held his cap flat against his thigh when he sat down. Most people in that room were watching the officer. I found myself watching Mr. Reed. He did not stare at Daniel Mercer. He looked at me, then at the clerk, then down at the papers on counsel table as if he wanted to understand exactly where this day was going to put him. He was not there for revenge. I could see that before he said a word. Later, when it was his turn to speak, he said, "I need the court to say what happened was wrong. I do not need the court to pretend prison is the only word it knows." That was unusual clarity. He was telling me, in plain language, that truth mattered to him more than theater. A courtroom can do a great deal with a person like that if it is willing to listen. Subscribe before I keep going. I am still thinking about what this case taught me. Subscribe, because before this video ends, I am going to try to say it out loud, and I want you to be here when I do. Subscribe now. The incident itself was ugly in a quiet way. No crowd, no long chase, no broken glass. Just a patrol car door opening, a white officer stepping out fast, and an old black man hearing a stranger shout at him as if age itself were suspicious. Mr. Reed had been waiting for his daughter to finish a shift at Rhode Island Hospital. He had picked up blood pressure medicine and a loaf of bread. He was standing beside the bus shelter because his knee hurt. Officer Mercer said from the stand, "I told myself I was reacting to movement. The truth is, I never slowed down enough to see the man in front of me." He said it without looking at his lawyer. That mattered to me. The footage showed that Mr. Reed was not reaching into a waistband. He was trying to lift his left hand while keeping balance on the cane. His coat bunched when he moved. Mercer saw the bunching and supplied the rest from his own fear. Fear was only part of it. Bias was the other part, and I will not speak around that. The dispatch call did not say armed. It did not say threatening. It said older black male, heavy coat, near parked cars. That was enough for Daniel Mercer to arrive not asking a question, but declaring an answer. He pointed a gun first and searched for facts second. The law notices sequence. So do I. What followed made it worse. Mr. Reed was ordered to his knees, though he had already said twice that his knee had been replaced and would not bend well. A shopper across the lot started recording. Another officer arrived. Mercer reholstered only after the second officer looked at the paper pharmacy bag and asked where the supposed threat was. 10 minutes later, Mr. Reed was released with no arrest. By 8:13 p.m., the report was written in language the video could not support. The legal tool I was glad to have in this case was a continued sentencing after adjudication and a full pre-sentence investigation. That sounds technical. At a kitchen table, I would put it this way. It gave me time. It let me look at more than the worst 5 minutes. It let me ask who had been harmed, what repair was possible, what pattern was real, and whether a sentence could do more than mark the damage. Strict rules matter. So does what a judge does inside the room. Those rules still leave open. My discretion in that case was not the freedom to ignore the law. It was the freedom to choose within the lawful range whether I would build a wall or a door. I could have sentenced Daniel Mercer to straight jail on the misdemeanor assault and false report counts. I also had the authority to suspend part of that time, order restitution, attach treatment, restrict future conduct, and require service that matched the harm. Discretion, in plain terms, meant I did not have to act as though punishment only comes in one shape. From the bench, I saw the entrances in a way no transcript ever can. Daniel Mercer came through the side door with his shoulders held too square. Men do that when they are trying to keep themselves from folding inward. When he reached the table, his right hand went once to his empty belt before he sat down. That would not mean much to someone watching from the back. From where I sat, it told me he had spent years reaching for authority without thinking. Now the belt was empty, and he knew it. Mr. Reed entered from the public aisle. He stopped once, not because he had to, but to let a young clerk carrying files pass ahead of him. He did not make anyone hurry to him. He waited. Then he put one hand on the rail and eased himself into the front row seat with the care of a man who had learned his own limits and did not resent them. From the bench, I could also see Loretta Reed keep her father's medication bottle in her purse pocket, cap already loosened. She had planned for stress before anyone spoke. The first turn in the case came from a sentence that was not legally decisive at all. It came from Daniel Mercer's own investigator, a retired lieutenant the defense called to speak about what Mercer had done after the footage surfaced. The man did not offer excuses. He said, "He did not ask me how to save his badge." He said, "Help me put the truth in the record before I ask for anything else." I remember the room becoming still after that. That sentence did not erase what Mercer had done. It did something harder. It forced me to reconsider what kind of sentence truth might deserve if the person finally telling it was the same person who had once buried it. I have seen defendants perform sorrow. I know the look. This was not polished enough to be performance. It had edges on it. I made a note in the margin of my file, "Watch what he gives up when truth costs him something." That happened sooner than I expected. During cross-examination, the prosecutor walked him through the report line by line. When she reached the part about Mr. Reed advancing aggressively, Mercer interrupted his own lawyer's objection and said, "Mr. Reed never moved toward me. That line was false." He said it plainly, no drama in it. Just a man cutting his own shelter out from above his head because he had decided, late but fully, to stop living under it. Subscribe if you believe that courts are not only places where people are punished, they are also, sometimes not always, but sometimes places where people are met with something more than they expected. Subscribe for those moments. This is one of them. The prosecutor did her job well. She did not let honesty arrive late and pass for a full defense. She showed the video frame by frame. She entered the dispatch audio. She put in the corrected report and the internal affairs finding. She called the civilian witness from the parking lot, a woman named Sandra Lopez, who said, "The old man looked confused before he looked scared. Then he looked scared." I wrote that down too, because it was exact. Mr. Reed testified with a softness that made the room lean in. He said, "I thought if I moved wrong, I would die in front of the bread I had just bought." There are sentences a courtroom hears and forgets because they are built to persuade. Then there are sentences that remain because they are built from the shape of what a person actually lived. That was one of those. It told me not only that harm had been done, but what kind of harm it was. Humiliation, fear, the loss of ordinary safety. The second turn came from a packet delivered to Chambers 2 days before sentencing. It was not a sentimental packet, it was a work plan. West End Senior Center had agreed, in writing, to accept Daniel Mercer for supervised service if I ordered it, and only because Elijah Reed had said he wanted that option available. Attached to it were Mercer's intake forms for racial bias counseling, a de-escalation retraining schedule, and the center director's conditions for his presence there. It was factual, specific, and structured. That matters to me. What changed at that moment was not my feeling. It was my range of action. Until that packet arrived, jail and fine sat closest to the front of the table. After it arrived, another lawful path stood there as well, one rooted in work, supervision, accountability, and the consent of the man harmed. I remember looking up from those pages and seeing Loretta Reed in the front row with both hands unclenched for the first time that day. She had been holding a notebook so tightly the spiral had marked her palm. Now it lay flat. The defense arguments, when they came, did not have to drag me toward mercy. I was already asking whether mercy could be made exact enough to trust. Defense counsel Andrea Klein was smart enough to know the difference. She did not waste time calling this a misunderstanding. She said, "If the court sends him home unchanged, then all we will have done is move the danger." That was more honest than most advocacy is. It treated sentencing as design, not rescue. Where the defense got it wrong was when she tried once to call it a split-second decision. It was not. I had counted the footage myself. 11 seconds passed between first contact and the point when the gun was fully trained. 11 seconds is enough time to see a cane, enough time to hear an old man say, "I can't kneel fast," enough time to choose not to turn uncertainty into a weapon. I said so from the bench, and I wanted the record to hold that. When Daniel Mercer testified at sentencing, I listened for the sentence that would tell me what he understood, not what he wanted me to think, what he understood. He said, "I saw an old black man and I filled in the rest before he did a thing." There it was. No borrowed language, no hiding inside policy. He named race. He named his own mind. That was one quote that revealed his circumstances and his failure at the same time. He had been trained, he had authority, he had still chosen a story over a person. A few minutes later he said, "Mr. Reed did nothing that justified my gun." That was the accountability quote. Clean, hard, not padded. He did not say he was sorry if anyone felt upset. He did not say the public pressure had been hard on his family and leave it there. He said the truth in a form that left him no place to retreat from it later. In my courtroom, I value that. Then he said the sentence that decided the shape of the case for me. He said, "If I lose everything and learn nothing, then Mr. Reed still loses." That was the moment I knew what I was going to do. I wrote it down. Not because I needed to remember it, because I wanted to. Subscribe. I am not going to make a speech about it. You are already in this story. Subscribe and let me finish. As he sat back down, something old returned to me. I was a boy again, walking with my father on a wet evening after supper. A man ahead of us, older than my father, dropped a bag of oranges in the street. Cars moved around him. Nobody stopped. My father bent down without saying much, gathered the oranges one by one, and put them back in the torn bag while the man stood there embarrassed and silent. I remember my father speaking to him at eye level. I remember the rain on the blacktop. I had not thought about that in years. I'm not saying Daniel Mercer was that man in the street. He was not. I'm saying that memory entered the room with me and took a seat where I could feel it. A courtroom asks over and over whether we are willing to see the person in front of us clearly enough to respond to the truth and not just to the easiest version of it. Some days the answer is no. That day I wanted the answer to be yes, if the evidence let me say it honestly. Before I spoke the sentence, I looked around the room the way I always do when I know words are about to matter. There was no dramatic silence. I do not believe much in dramatic silence. What there was attention. Mr. Reed had both hands over the top of his cane. Loretta was turned half toward her father, half toward me. Daniel Mercer was sitting very still, but his jaw had begun to work at the side, the way a man's jaw works when he is trying not to speak over his own fear. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I found Daniel Mercer guilty on the assault and false report counts. I said the word slowly because I wanted there to be no confusion about what I was doing. I said that drawing a gun on an unarmed elderly man without lawful cause was not a close call. I said that writing a report afterward to make the act appear justified was an added wrong, not an afterthought. Then I moved to sentence. I said, I am ordering you to pay restitution in the amount of $2,800 to Elijah Reed. That money is for counseling visits, transportation to those visits, and the security camera his daughter installed outside his apartment after this happened. Money does not repair fear. It can at least cover some of the bill fear left behind. I said, I am also ordering a fine of $1,000 to the Rhode Island Center for Justice Education, earmarked for community training on de-escalation and police encounters with older residents. You used public authority in a way that broke public trust. A public cost should answer that. I wanted the financial part of the sentence to point somewhere beyond the ledger. Then I said, I'm ordering 300 hours of restorative service at West End Senior Center, supervised, documented, and done in person. Not paperwork from home, not a check written by somebody else. In person. At least 100 of those hours must be in direct assistance to elders with meals, mobility, or reading services. You pointed a gun at an old man because you failed to see him clearly. I am requiring work that makes you slow down and see people up close. I said, I am placing you on 18 months of probation. During that period, you will complete a certified racial bias program, a de-escalation course approved by this court, and monthly counseling with reports filed to probation. You will not carry a firearm under any private or public security role during that period unless another court or licensing body clears it after these conditions are met. The evidence showed me that punishment by itself will not correct what happened, structure might. And there was one more thing. I said, once each month for 1 year, you will attend the Community Listening Forum at Ebenezer Baptist Church on Prairie Avenue. You will sit through the full session. When invited to speak, you will answer plainly and briefly. You are not going there to defend yourself. You are going there to practice being accountable in public without the shelter of a badge. That was the most human part of the sentence, and also the part that demanded the most of him. I added one condition for early completion. I said, if you complete the first 150 hours of service, every counseling session, every class, and if you go 12 straight months without a violation and with full compliance reports, I will consider a motion to reduce the remaining probation by 6 months. That was my benchmark. It was my way of telling him the future was not closed if he proved in actions that he could live inside a better one. Then I addressed him directly. I said, what you did cost Elijah Reed his sense of safety in an ordinary place on an ordinary evening. It cost his daughter's sleep. It cost a neighborhood another reason to doubt that authority can tell the truth about itself. I turned slightly toward Mr. Reed when I said his name. He deserved that much, at minimum. Then I looked back at Daniel Mercer and said, "You are not the charges filed against you, but you are responsible for them. I believe you can do this work if you stop asking whether it is fair to you and start asking whether it is useful to the people you frightened." That was my explicit belief, stated as plainly as I knew how to state it. I meant it. I ended with one sentence to him as a person, not a case. I said, "Do not make this courtroom the last place where the truth catches up with you." I let that sit there. Then I signed the order. "Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell." What I noticed first after the sentence was not Daniel Mercer. It was Loretta Reed. She stood, walked to the defense table, and placed a folded brochure from West End Senior Center in front of him. Then she said, "Tuesday is at 9. Don't come late." He nodded once. He did not reach for the brochure until she had gone back to her father. I watched that from the bench and said nothing. Before I stood up, I did one small, ordinary thing. I straightened the stack of exhibits with both hands and lined the edges against the wood. I do that all the time. On that day, it felt different. It felt like putting the papers back in order after the people in the room had done something harder than paper. What happened after is not a broad summary. It is one specific thing on one specific date. On October 15, 2024, a compliance note from the director of West End Senior Center crossed my desk. It said Daniel Mercer had arrived at 8:52 a.m. He is signed in early and spent part of the morning pushing lunch carts, replacing worn tennis balls on the feet of walkers, and reading mail aloud to two men whose eyesight was failing. That note did not say he had become a different man. It said he had done a different thing. A week later, Elijah Reed sent the letter I mentioned at the beginning. Near the end of it, he wrote, "What helped me most was that he had to look me in the eye and stay there." That was the second quote from the victim I have carried with me. Not because it tied everything up neatly, it did not. It told me something more useful. Sometimes what a harmed person needs is not maximum pain returned outward. Sometimes it is sustained truth. No appeal was filed. Neither side sought one. I noticed when the deadline passed, I will be honest about what that meant to me. It meant the sentence was going to be lived instead of argued over. There are cases where appeal is necessary and right. This was not one of them. In this one, the work mattered more to me than another round of paper. What I came to believe through this case is simple. Mercy costs precision. It asks more of a judge, not less. It would have been easier to give a sentence that sounded tough and ended the matter at the courthouse door. Easier for me. Easier for the headlines some people prefer. Harder was designing something narrow enough to fit the harm and strong enough to ask real change from the person who caused it. What the case showed me again is that vague mercy flatters the giver. Precise mercy burdens the person receiving it. One is a feeling, the other is a plan with dates, names, reporting conditions, financial terms, and consequences if it is ignored. That is the only kind I trust. It is also the only kind that has ever given me reason to believe I did not simply choose the softer road because it felt better. This case gave something back to me as a person. It gave me back a piece of trust I had begun to hold too tightly. If you have been where Daniel Mercer was, if you caused real harm and now you are waiting to see whether any path forward exists, I can tell you one specific thing I look for from the bench. I look for truth that costs you something, not polished regret, not borrowed language, truth that leaves you with less shelter than you had when you walked in. If you know that, then start there. Say the part that hurts your own case and is still true. And if you have been where Elijah Reed was, if someone hurt you and people around you kept trying to tell you what you were supposed to want in response, I will not tell you what to want. That is yours. I will only tell you what I have witnessed. The victims who chose mercy in a careful, bounded, accountable form did not seem smaller to me later. They seemed less tied to the worst minute of their lives. That is not a guarantee. It is only what I have seen. I go back now to that line in the letter. He came every Tuesday and he pushed the lunch carts without talking unless somebody spoke to him first. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay.